So one of the preferred forums for litigating or resolving a federal tax dispute is the United States Tax Court. The United States Tax Court is an Article I court of which there are several judges of different tiers, either traditional trial judges, special judges, or senior judges, that hear federal tax disputes. It is by volume, the highest utilized court when it comes to addressing federal tax disputes, for the reason that it is a prepayment forum. So when a taxpayer has a dispute, for example, with the IRS and is unable to resolve it, they can, within a certain period of time, get into tax court without paying the tax first. That is unique and different from all of the other federal tax litigation forums, for example, district court, court of claims, etc., where the taxpayer must pay the entire amount of the assessment first and then litigate to get the money back. The United States Tax Court allows a forum to address the dispute without first paying the tax. And so for that reason, and also the ease of which it is to petition the court for the price of $60 and a postage stamp, you are able to litigate in that forum. It is the preferred venue for litigating these type of cases. Now, to get into tax court, because it is an Article I court, there is only so many ways to do so. We have to have what we call in the business as a ticket to tax court. You have to have some type of notice or determination from the IRS before you can get in there. The traditional is a statutory notice of deficiency. So at the culmination of an audit, either the case is agreed or unagreed. If the case is unagreed, eventually by law, before the assessment is made, the IRS must send a notice of deficiency. That would be a ticket into tax court. So petitioning the court with that notice in hand within the 90 days required by law would allow a taxpayer to continue to litigate and dispute the IRS determination. Other examples of tickets to tax court would be notices of determination in a collection due process hearing, a notice of determination with respect to a whistleblower claim, or what we're seeing now is notification of certification of passport revocation status. Any of those might entitle a taxpayer the opportunity to go into the tax court. Once in tax court, the adversary becomes generally speaking, the IRS Office of Chief Counsel. They take the place of whomever the taxpayer was dealing with at lower levels of the IRS, whether it was a revenue agent or a tax compliance officer. And although the Office of Appeals can still be an option while being a docketed tax court case, the ultimate decision is now with the Office of Chief Counsel to dispose of the case. The case will either be disposed of by agreement. The petitioner, which is synonymous with the taxpayer, agrees and accepts the finding. The parties agree to something else, or ultimately, if it needs to be tried before a United States Tax Court judge.